third parties and a duty of care. What does that mean? What's a third party? Third party starts typically about 2 a.m. Nah, just kidding. Let's talk about third parties because you've probably heard the expression third party and you didn't want to, hey, what does that mean exactly? What it means exactly is this. Contractual agreements, typically the ones that you're going to be entering into or your firm is going to be entering into, are between two parties. Party of the first part, party of the second part. First party and the second party. Third parties are individuals or organizations or other entities that are somehow associated with the project, but they're not one of the two parties in the contract that are in privity with one another. They're the third parties, they're outside. Duty of care. You have a duty of care to these third parties. To some extent, it's almost like the Hippocratic Oath. First, do no harm. You need to conduct yourself in everything that you do with the concept that the public always is client one. I owe my first duty, my first allegiance to the public. Which means that if somebody asks you to do something that you know is going to cause a problem, the potential for damage or injury to a third party, you may have to say, no, that I will not do. And there are any number of reasons why you're going to do that. We can reinforce that besides the moral, ethical reasons. Do it right or don't do it at all. Prosper through professionalism. These are basic, fundamental tenets you absolutely need to adopt. You need to bring into the fabric of your own being as a professional. That's what it's all about. Consider this. Let's talk about an absurd hypothetical example. A fellow goes to a heart surgeon. Heart surgeon says, you need to have a heart transplant. The individual looks at his insurance and sees, gee, there's kind of a deductible on this. He says, listen, doc, tell you what, I need to save money. So when you're sewing me back up, rather than using like needle and thread, what I want you to use, go out, get some super glue, get some Loctite or something. Put a couple of drops on that, man, just go squeeze it together. I'm as good as new, and that'll save a lot of time and money. The doctor is going to say, no way, I'm not going to do that. It's wrong. Besides, something is bound to go wrong with something like that, and you're going to sue me. And guess what? Of course, the physician is absolutely right. The individual who has requested something stupid and gets it isn't going to come out right, and the individual is going to sue. The argument is going to be, well, the physician should have known better than to agree with me. What do I know? The exact same dictum applies to you. You know better than your client. If you go along with a stupid request made by the client isn't at fault, you are. You can't say, boy, did I have a dumb client. No, the client is going to say, boy, did I have a dumb professional. And the client's going to be right. You owe a duty of care to that client because you know something the client doesn't know. Now consider this. This is not quite so hypothetical. You're working for a developer of some kind, and the developer is looking around and he says, if you design this surface drainage system for 100-year flood, it's going to cost me some dough. But if you design it for a 5-year flood, we can save a lot of money. So I want you to design it for a 5-year flood, or I'm going to get somebody else who will. Your response on something like that should be, client, you're stupid. You never should do it that way. And by the way, if you're going to have to get somebody else, go get somebody else. Because what you're asking me to do is wrong. We design for a 100-year flood to protect the public. Think about this. You design instead for a 5-year flood. Well, that's what the client wanted, you say. And you save the client a lot of money. The client is real happy. The client is a limited liability company. Everything is built. The client collects the money and shuts down the company. That's why it's called a limited liability company, and the client is gone. A couple years go by. Son of a gun. There's a big thaw. A lot of water collects. The amount of water that collects overwhelms this under-designed system. As a consequence, there's a lot of property damage, a couple of automobile accidents because of flooding and what have you. And they check the records, and they see that you have designed for a 5-year flood, not a 100-year flood. And your defense is, well, this is what the client directed me to do. And they're going to say, well, you know that people around here don't do that. Most people design for a 100-year flood. They do a survey. They find that, guess what? The standard of care is a 100-year flood design. You did not abide with the standard of care, and you have caused damage. Therefore, by definition, you're negligent. Worse, you did it intentionally. This wasn't accidental stupidity. This was intentional stupidity. Your insurer is going to tell you, sorry, we don't cover that exposure because it is willful. It was intentional on your part. It wasn't a mistake. You didn't try to do the right thing. You knowingly did the wrong thing, and that is excluded from coverage. In essence, that's what gross negligence is all about. And the courts may review it and see it as gross negligence, and as a consequence, you may lose your license. All, by the way, most deserved. You're a professional. You don't do that. You owe a duty of care to the public, and part of that duty of care is to say, no, I'm not going to do that. We don't do things like that. I'm a professional. We don't do that stuff. Questions will arise as to whether or not you actually do owe a duty of care to a third party. Often, the issue will hinge on the matter of foreseeability. In other words, was it foreseeable that by virtue of your action or inaction, that a third party would have been damaged? There are several cases that underscore what foreseeability is all about. One of them we call the case of the condo conversion. An older couple had settled into retirement, and they decided that if they built a quadplex and lived in one of the units, they could rent out the other 3 units and use the money they received to pay their expenses and every now and then take a vacation, something like that, and do pretty well. So they took some land they owned, and they retained an architect and said, design us a quadplex. Now, they emphasized the fact that they had to have low first cost. In other words, make it as cheap as humanly possible. When it comes to paint, specify the cheapest grade there is, the worst kind of wood. Everything that was done had to be cheap, cheap, cheap. Had to abide by code, but it had to be just minimally so, the cheapest that you can make it. The cheaper, the better. The architect obliged, and there's nothing wrong with obliging in that case. The duty of care is owed to the clients. In this particular case, you abide by code relative to safety and so on, you're all set. The quadplex was constructed, everything was moving along according to plan for the older people. Then, the condo craze hit the community. They converted their quadplex to 4 separate units. They took the money, a nice, healthy profit, and moved. They're gone. Now, the 4 families that purchased these units noticed shortly after they moved in that the paint was peeling, the wood was falling apart, the banisters were falling off, the heat pumps were breaking, the roof was leaking. In other words, the whole place was falling apart. It required an inordinate amount of repair and maintenance because it was built so cheaply. Well, these people couldn't sue the original owners. They had moved. Who was left to sue? the contractor. You can't sue the contractor. The contractor built it according to plans and specs, didn't do anything wrong. Aha! The architect, because the architect, after all, is personally liable, yada, 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 will go after the architect. So they sued the architect on the ground that the architect knew or should have known that the older couple would convert the building to condominiums, and therefore the architect owed a duty of care to the people who ultimately would buy those units, and therefore should have specified better quality stuff, blah, blah, blah. Often in lawsuits like this, what they're hoping to do is have the architect simply throw in the towel and say, look, rather than fight you, I'll give you some money, go away, because it's cheaper to pay you off than it is to fight it out in court. Well, in this case, the architect decided not to do that. The architect said, you know what, that's it, I'm not taking this stuff, I'm fighting you. And the architect sought to get a dismissal. The architect went to the judge and said, look, Your Honor, here are all these documents that I have. The couple said they were going to be living in this quadplex for the rest of their lives. It was not foreseeable that they would convert this building from rental to condominium. The judge reviewed the papers, and the judge said, you know what? I agree with you. It was not foreseeable. Case dismissed. Win one for the good guys. In the next case, we have a situation where an architect designed a jail. In each cell, he specified there should be a coat hook because the individuals arrested might be wearing a coat, and it might be a nice one, you know, and they don't want to just throw it on the floor. As it so happens, one evening a young man was arrested, and he became despondent, or was despondent, who knows why. It may have been because of natural circumstances, maybe he had imbibed a substance of the wrong type, whatever. He was very depressed. And that evening, regrettably, he took the laces out of his shoes, he tied a noose for himself, one end of it went around his neck, and the other end of it went around the coat hook, and he committed suicide. His family was extremely upset. They retained counsel, and counsel sued the local jail, the community, everybody else it could, including the architect. It was said that the architect owed a duty of care to the young man, and it was foreseeable that people who were jailed could become despondent, and as a consequence of that despondency, seek to terminate their lives, which of course is exactly what happened in this instance. The architect fought the charges and, like the prior architect, sought for dismissal. But the judge said, I'm sorry, we are not going to dismiss. And in fact, the jury ruled for the plaintiff. They said it was foreseeable that something like this could occur, and therefore the architect was negligent for failing to consider the risk, and in the design of the jail, for failing to exclude anything that could be used for purposes of suicide. Which is why if you visit a jail, you'll see that there are no coat hooks, and should you be taken away to jail, you better be wearing loafers, because anything else you're going to be wearing is certainly not going to have laces in it. In the third case, the case of the angry drunk loser, an individual went to a racetrack and was gambling, as people at racetracks often do, in the clubhouse. Nice air-conditioned clubhouse, sitting there at a table. I'll have a drink, says he. He has a drink, bets on the first race, loses, but what the heck, he's in a happy mood. I'll have another drink, says he, bets on the second race, loses again, and so on all the way through the 10th race. But at the end of the 10th race, he's not so happy anymore. He's angry. He's lost 10 consecutive races. And in his anger, he takes an ashtray and with all his might heaves it through the glass of the clubhouse windowed wall. A woman sitting in the clubhouse is seriously injured by a piece of glass that comes down and impales her. Among other people that she sues is the architect for failure to specify safety glass because she said it was foreseeable that someone could lose a lot of money at the races, get ticked off, be drunk, throw something through, etc. Once again, the architect fought it, and once again, what do you think? The judge said it was foreseeable or it wasn't. In this particular case, the judge says, sorry, that was not foreseeable. But how do you know how the judge is going to rule? You don't. It's what's called a crapshoot, because in each of these three cases, not foreseeable, foreseeable, not foreseeable, realistically, with different judges, could have been foreseeable, not foreseeable, foreseeable. What you need to do is sit there, do your very best to analyze the situation, evaluate the risks involved to see what is and is not foreseeable, and advise your client accordingly. If you believe that a given risk really is foreseeable and the client says, don't worry about it, worry about it. If the client says, don't worry, if anything goes wrong, I'll indemnify you, I'll take care of you. No, the client can't. It is against public policy for anybody to pick up your liability and to say, I will hold you harmless no matter what you do. The law is such that it wants you to bear liability for stupid acts, because that's how it discourages you from doing stupid things. You cannot have somebody else pick up your liability. They can limit it, but they can't pick it up altogether. So if the client says, don't worry about it, I'll take care of you, doesn't work that way. And let's say that the client says, okay, I understand that. I cannot pick up all your liability, but at least I will limit your liability so that the penalties are not so egregious if you just help me out. But what happens if that client is, for example, a limited liability company, and a year, 6 months after completing the project, the client dissolves and isn't there anymore? Who is left holding the bag? Let me give you an expression you need to learn. Moo, because that's the bag you're going to be holding. Here's something else that doesn't work. But everybody is doing it. Everybody does it this way. Let me continue that so it sounds familiar. But Mom, everybody's doing it. Or, but Mom, no one does that. Well, says Mom, or Dad, if Jimmy Jones is going to jump off the end of the pier, are you going to do it too? A defense based upon what others were doing at the time, when clearly they were doing something wrong, will not hold water. This has been shown time and time again. It was shown in particular in a case history I really lived through with a friend. It occurred a number of years ago in a major metropolitan area where a condominium development was underway. It involved 3 large buildings. 2 of them had already been designed and built and sold without any problem whatsoever. The 3rd one was under construction at a time when really the city's construction industry was in a frenzy. They just couldn't get enough material. They couldn't get enough people to do everything that had to be done. In this particular case, the structural engineer of record was a partnership. And the partner who actually had done the design on these 3 identical buildings was taking a vacation, and he said to his partner, who we will call Chuck, he said, Chuck, I want you to, if something comes up, can you take care of it? And Chuck said, no problem. This was for the major developer in the city, being built by the major contractor in the city. This was first class all the way. But the contractor had a difficulty. The contractor didn't have enough people to do everything that had to be done. So what happened was the same thing that happens to a lot of people in this situation. You lie to yourself about the qualifications of the people available. You say, hey, are you in a position to take this on? You've been with us now. You have this much experience. Can you do it? And in this case, the young man to whom they assigned this responsibility said, sure, I'll do it. But he really wasn't capable of doing it. And as a consequence, there was an oversight that occurred. And in essence, what happened was that B was done before A, and this created a fatal weakness during construction. Structural engineers at the time, and even now, do not provide ongoing full-time construction observation. They make what's called occasional visits to the site to help ensure construction is proceeding with the intent of the design, whatever that means. Essentially, as near as I can figure it out, it means this. Hey, is this a condominium? Yes, sir, it is. Okay, that's my intent, and move on. I don't mean to make a laughing matter out of it, but really, I don't know what it means beyond that. In any event, in this particular case, construction was ongoing. During construction, they had to strip some of the concrete prematurely because there was a shortage of plywood. And this applied in particular to some balconies that were being built. Now, the local code required the structural engineer of record to sign off that the stripping was permissible. So, in this particular case, the structural engineer, Chuck, sitting in for his friend who was on vacation, was approached by representatives of the contractor who said, here are a bunch of stripping orders, how about signing them just the way everybody else does? Which in fact was true. Everybody else did just sign them. They kind of like winked at the regulations. And as long as nothing goes wrong, no harm, no foul, hey, it's okay. So Chuck signed the forms and said, sure, it's okay to strip. And so they stripped. Because they stripped the balconies prematurely, the concrete had not fully set up, hadn't dried out. It was heavy. It was heavier than the supporting structure involved, and it fell. It fell in the balcony below it, which fell in the balcony below that. Well, ordinarily, if a balcony collapses, it's a big deal, but it's not that big a deal. In this case, it was. Because the building was built with, not designed with, but built with a fatal flaw. Because B was done before A. When that balcony fell to the balcony below it, and those two fell on the third, which held, the entire facade of the building fell off, and 12 workers were killed. And the headlines, of course, in the newspapers were, especially the major daily newspaper, 12 workers killed in construction accident. And then it went on to describe the gory details. This was a major disaster. Workers' compensation kicked in, of course, to protect the contractor. The young man who was the construction superintendent was absolutely distraught because he knew that he had made the mistake that led to the problem. Attorneys for the families of the injured and killed workers, of course, were not about to let it go at that. They pointed to the fact that the engineer had signed these documents that they discovered through discovery in the files of the contractor. It's okay to strip. The engineer should never have signed those documents, even though everyone else at the time did. Wrong thing to do. Really, no matter, even though they were stripped prematurely, the balconies falling shouldn't have caused the facade of the building to fail. It failed because of something the contractor did, not because of what the engineer had done. In fact, again, the engineer had designed the same building twice before. It worked fine. So had the architect. No problems whatsoever. And they had any number of experts at trial who said, look, it couldn't possibly have been the fault of design. The collapsing of the balconies could not possibly have caused this. It would not have happened were it not for the fact that there was an error during construction. If the trier of fact went along with that contention, however, then obviously these 50 people, the wives of the dead workers, their children, what would they get? Nothing. Absolutely nothing at all, other than what was provided by workers' compensation. They didn't have insurance. They had no way of educating their kids, no money, no hope. This is a pretty terrible situation. And so, of course, the trier of fact, a jury, was going to do what it could to help them. And what it found was that the engineer and the architect were negligent because of their design and because the structural engineer, of course, had signed these documents and da-da-da-da-da. The end result? Headlines in the paper, structural engineer negligent in death of 12. And that, in essence, was the end of his career. The firm had to be dissolved. His reputation was sullied beyond repair. This from an individual who was generally regarded as the dean of the structural engineering community in that particular city. Everybody did this, though. Yes, everybody did it, but in this case, it resulted in a terrible loss of life. And that's all she wrote. Was this foreseeable? Of course it was. The fact is that the engineer signed something, kind of as a favor to his partner, that he should not have signed because everybody did it. Something bad could have happened as a result. This is not the kind of requirement that you simply wink at. You can't. It's there for a reason. If you don't do it right, obviously something bad can happen. What is foreseeable and what is not? Everybody's doing it. Well, I'm not, because it is wrong and I know it to be wrong. No, this I will not do. I am a professional. I owe a duty of care. I am responsible for doing everything I'm supposed to do and for not doing things I'm not supposed to do. The consequences of failing to abide by this credo can be far-reaching. Do your best to educate your clients about your responsibility, what you have to do. If you have clients who say, if you don't do it this way, I'll find someone who will. Let them. There are other clients who will say, you know what, I appreciate your professionalism. Remember, you have special knowledge. The public relies upon you to exercise that professional knowledge wisely, ethically, with their interest held foremost. In everything you do, the public should be client one. In everything you do, you need to be a pro. You need to be a professional. You will prosper through professionalism. You will prosper by doing it right or not doing it at all.
eBrownbag.